its staff, management, or sponsors.
Are you a family caregiver? Are you caregiving for someone who can no longer take care of themselves? Are you overwhelmed? This is Caregiver Solutions Info with Marcia Teele. Marcia will be hosting an hour of true stories and information, tips and updates of the latest research and necessary information in the caregiving field, focusing on you, the family caregiver. An Alzheimer's disease and dementia care expert, Marcia has 15 years of hands-on experience at Arden Courts, a leader in assisted living dementia communities here in the U.S. Marcia covers everything you need to know as a family caregiver, especially if you care for a loved one with Alzheimer's disease or other related dementia or chronic illness. If you have a friend or relative that is also a family caregiver, call them now. They won't want to miss a minute. And let them know they can watch on caregiversolutions.info. And they can listen on WNN 1470 AM in South Florida or nationally on the iHeartRadio app. Now, sit back, relax, and learn from our host, Marcia Teele, as she brings information to you that may just be the caregiving solution you need.
Hi, everyone, and welcome to Caregiver Solution Info Show. I'm your host, Marcia Teele. I'm so glad that you could join us today. We have a wonderful program for you. If you're a caregiver, especially a caregiver caring for someone who can no longer care for themselves, then this show is made just for you. It's a wonderful educational platform to learn and to grow from and to possibly learn things that are going to really help you along your caregiving journey, because it's not easy. And as a caregiver, you don't learn this in school. This is something, it's sort of on-the-job training. And so we do need to educate ourselves when we find ourselves in this position and find out what we need to know, when we need to know it, when we need to do it. And this is what this show is all about. So I'm very happy today that we're going to be talking about a lot of legal issues and things that can be quite confusing sometimes that caregivers really need to know. A lot of people think they know certain things or they've talked to other people, but it's very, very important to really get the facts so that you don't make any missteps along the way. So joining me today from Advocates in Aging, the law offices of Wiesner and Smith, I have joining me Ira Stewart Wiesner and Daniel Smith. Welcome, gentlemen.
Thank you very much.
Thank you, Marcia.
I'm so glad to have you with us today. I want to just introduce you a little bit because, people that they always say, well, gosh, I have an elder law attorney, and I have an attorney, but what's the difference? And I'm going to let Ira talk about that, but I want to recognize you first, Ira, because you have been actually nationally recognized as an elder law attorney and the founder of Advocates in Aging, and you specialize in elder law, Medicaid planning, asset protection, special needs planning for the disabled. You do a lot of estate planning, and because of your advocacy for the seniors, you are now a fellow of the National Academy of Elder Law Attorneys. So all that being said, what's the difference between an elder law attorney and just an attorney in general, and why would people need one over the other?
All right. Well, Marcia, that's probably the key question of the afternoon. And the reason you would want an elder law attorney to focus on these kinds of issues is that our focus when we're working with a client is not a specific little thing. It could be, it's not a real estate sale. It's not a lawsuit. It's not a business transaction where we're focusing on one thing. What we're focusing is on the client. It's a client-centered practice. And so we're able to take in those issues that affect seniors, if it's their real estate, or if it's their IRA, and how to deal with their IRA, how to arrange for care in the home, how to arrange for it in a facility, how to plan for those kinds of things. And we have this whole picture in mind. And so you could go to an attorney and get a will, a trust, and a power of attorney. But they're more than likely, unless they're an elder law attorney, are not going to be looking to find out what your issues really are. And is there a dementia in the picture? What are the finances looking like? Who are your surrogates? Who are your agents if somebody becomes ill? Who takes on the responsibility if something happens to the caregiver? So it's a comprehensive representation that's not just the substantive area of the law. It's not just contracts. It's everything that impacts seniors. And what's interesting is all of those things tie into each other. They're not separate. And so a good representation is going to cover everything comprehensively and anticipate problems that the client doesn't anticipate.
Well, thank you. That's really important because you're putting it all together. You are looking at every aspect as opposed to one part, which I think if we had to make a comparison, it could be like a lot of doctors give medications out for different issues in the body, and this doctor will prescribe one medication, this one another. But if you have somebody that's looking at all of those medications together, say a pharmacist, they can see if there's any issues, any interactions, any problems that they can look at and say, gee, maybe we need to tweak this or that because this is really not going to be the best outcome because, you know, I need to look at the big picture and look at all the parts that make up the puzzle. So I don't know if you agree with that analogy, but I just thought of it and
it works for me.
Marcia, yeah.
Hi, Daniel. I want to introduce Daniel Smith. He's the partner there in the law firm, and Daniel is joining us too, and he focuses also on elder law and Medicaid planning, veterans benefits, guardianship, and more. And so, yes, Daniel, please.
Oh, yes. I was just going to add to your analogy, Marcia. Think of it like a general practitioner is like your primary care physician, for the doctor analogy. And think of us kind of like the dermatologist, right? Your primary care physician sees that you have a mole on your back that doesn't look quite right. I'm going to refer you to a dermatologist. So instead of the mole issues, we take care of the elder and senior issues. So kind of like that, just to build on your analogy.
Oh, thank you. Yeah, and I think it's so important, you know, because you all specialize. And, you know, when you're dealing with life-changing situations, you got to go to the specialist. You want the best. You want the best medical care. You want the best financial advice. You want the best legal advice. So that's why we have you all here. And I thank you again, you know, for being with us so much. It's going to be really, really a great program to educate caregivers today. So that being said, Ira, I know that you started the practice, the Advocates in Aging of the law firm. How long have you been in practice?
I opened my office in 1983.
So I think you have quite some experience.
A little bit, and we've moved into exclusively elder law probably around 1989, 1990. And
you certainly are in. I'm sorry, go ahead, Ira.
You mentioned in the very beginning about when you're a caregiver, you didn't come in with a manual. You don't know what's ahead. And it's a day-to-day learning experience and a struggle. It's enough of a struggle to deal with the situation you have with the person you're taking care of and taking care of yourself. And what we do is we guide you through those things that you don't know, so that everything as best as possible can operate smooth. Life kind of will go like this when you're doing caregiving. Our job is to make sure that the background is solid is sturdy, and that's not a cause for more concern.
Thank you. That's absolutely right. Caregiving is hard, and caregivers don't know which path sometimes to travel down, and they get, misinformation, or they stumble, and so this is really, really good for them. We're going to talk about a hypothetical couple today, and we're going to call them Wendy and Harold. And I thought, you guys give presentations a lot, and you like to use this type of teaching because it's talking about a hypothetical situation, but in reality, it could be an actual situation. It's very common. We're going to talk about with a couple, and they've been married a long time, and how their life is progressing, and going and following this couple with what they need and helping them to understand where the pitfalls are and how to plan accordingly so they don't run into those pitfalls. So we're going to talk about that when we come back, set up the scenario, and help Wendy and Harold and everybody else who is a Wendy and Harold listening to the program today will definitely benefit from this. So we're going to take a quick break, and we'll be right back with Caregiver Solutions Info Show.
Arden Courts is not just a place to live, it's a place to call home. Residential living combined with quality caregiving. This is the philosophy behind Arden Courts. Communities created exclusively for individuals with Alzheimer's disease and related dementia who would benefit from a safe and structured environment. For additional information about any of the unique services Arden Courts provides, call 888-478-2410 to locate a community nearest you. Inquire about our educational seminars, resource library, or support groups, or simply feel free to ask questions you may have about Alzheimer's and related dementias. At Arden Courts, we know, we understand, and we can help because memory care is all we do. Remember, call 888-478-2410 for additional information about any of the unique services Arden Courts provides. You are listening to your host, Marcia Teele, an Alzheimer's disease and dementia care expert on caregiversolutions.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
My guests today are very special people. We have from Advocates in Aging, the law offices of Wiesner and Smith, and they're here to talk about legal issues that all caregivers should be aware of. So gentlemen, again, thanks for being here today. We're going to start with a hypothetical situation. Two people, we're going to call them Wendy and Harold. I'm going to give everyone their factual background, and they might sound like a typical couple from anywhere, but we're making this up for the practice and for the purpose of education. So this is what Harold and Wendy are all about. They recently moved to Sarasota, Florida, from New York to live here full time. Their New York attorney previously did all of their estate planning documents. Their New York estate planning documents include advance directive for health care, a living will, designation of healthcare surrogate, a power of attorney, a last will and testament, and lastly, a joint revocable living trust. So that sounds to me that Wendy and Harold really got everything they needed up in New York to take care of their whole life planning going forward, because we're assuming they're an elderly couple. They've been married quite some time. So that's, Ira, don't you think that this sounds like they've done a really good planning in New York?
They have definitely started, and they have at least given consideration to it. They have something in place, and they knew that there's a value for doing that. Oftentimes, we'll deal with couples, caregivers, spouses, where they've never done any of this. There's nothing in place. And so we have to deal with what are the risks of not having it, as well as what are we going to deal with if they transpose from another state, whether it's New York or Illinois or any place else. The most important thing that I can say for a caregiver is that you have to have the authority to do what needs to be done, because the person who you're caring for may not be able to participate in that process. I'll give you a little example. The care recipient has an IRA, and they have to determine what are the required minimum distributions that have to be taken out of there without a tax penalty, but they can't remember any of that. And so you call the IRA holder and they say, well, can you put your spouse on the phone? And they can't speak on the phone. They can't deal with it. Then they ask, well, do you have power of attorney to act for them? And if you don't, the consequences can be very dire. And some of those Daniel will address at the end. Here we have Harold and Wendy, and they've come down from New York, and they have some basic documents. And so their first question is going to be, well, don't I have what I need? Do I have to redo any of this? Do I have to make them Florida documents? And this, Marcia, applies whether they're coming from New York to Florida, from Ohio to California. Whenever you transition to a state, the question comes up, are the documents you have going to work? The question is not whether they're legal or valid. The question is, are they going to work? Because these are documents that you are presenting to a third party, to a bank, to a broker, to an IRA custodian. And if they don't accept the document, then you end up needing a guardianship to move forward. So it's not a question of whether it's legal, valid, it's whether it's enforceable, whether they're going to honor it. And we'll start off advanced healthcare directives, healthcare issues. It's the appointment of someone to make medical decisions if you can't, or when you can't. And so what we want to make sure is that the health providers that you're going to deal with will recognize that document. If they're in Florida, they're not going to hire a lawyer to find out for them what a New York power of attorney is supposed to have in it. They're going to throw up their hands. And so we want to know that we have a document that they're going to see, that they're going to recognize, and that they're not going to have a problem with. And so we'll take the advanced healthcare directive. Now, it may seem that healthcare documents where you appoint your surrogate and make certain decisions in there would be uniform everywhere, but they're not. And I'll give you a couple examples, and these are the things that our listeners and viewers should pay particular attention to in their documents. First is that under Florida law, if I appoint my wife, if Harold appoints Wendy to be his healthcare agent, surrogate, okay? Under Florida law, Wendy doesn't get a chance to even comment until the doctor says she can. The doctor actually controls, like a switch, whether or not Harold can act for Wendy. The legislature now allows us to say that no, when Harold named Wendy to be his agent, he wanted her to act. Doesn't say he can't, but you know, if you've ever been in the hospital and you're not feeling well and the doctor says you have XYZ condition, you can't get on Google and research it. You can't look at other alternatives and the risks of everything. You need someone to help you. But if they can't get access to your medical records, if they can't hire and fire doctors, they have no power until the doctor in charge lets them. So the first thing is to consider making it immediately effective. That way you have someone in there that can assist. The second and the most important is what we call HIPAA authorization. Now HIPAA stands for the Health Insurance Portability and Protection Act that went into effect many, many years ago. It's medical privacy. And unless you've designated your healthcare agent to have that authority, the doctors and the hospitals can't confer with them about your medical condition. It's a violation of federal law. So again, let's say Harold names Wendy as his primary agent and gives her HIPAA authority. If he also wants to give that kind of HIPAA authority, he can give it to the kids, so that if a daughter up in Ohio calls the hospital in Boynton Beach and says, well, how is Wendy doing? She'll get that information. And so HIPAA authority becomes really the key to doing this. And then finally, dealing with a living will, which says, I don't want to be kept alive artificially. That should be in place so that if the condition deteriorates to the point where you have to keep going with machinery and breathing tubes and things like that, that you've said what you want. It's not as much important as to what you want, it's that you declare it, and so the people understand it. And that's really what we're looking for in terms of healthcare decision making.
Well, some of that sounds so like a little technicality, but it comes with a huge difference with having it and not having it. And I like that you pointed that out, because some people may not see that as being a big deal, but it's a big deal. It's a real big deal when you're. Mm-hmm. You can't
Marcia,
get the information you need. Yeah, it's a big deal. So the bottom line is, it sounds like what you're saying is that when people move from state to state, they need to either change it or find out from their provider who they're dealing with whether they would accept it or not, and not wait for a crisis.
Never wait for the crisis. Everything here is to set the mechanism in place so that you don't have problems. The same thing applies for power of attorney. Now, a power of attorney is a document that says that you have the authority to do whatever it says in the document to do. Ordinarily, that could be pay my bills, handle my banking, deal with my insurance company, deal with my IRA, make gifts to the family, provide for my spouse. Whatever it is in Florida that you want accomplished, you have to put it into the power of attorney. Now, in Florida, we also have some technicalities that if you want to do Medicaid planning or gifting or anything like that, you have to specifically put that in there and initial it. So Florida is very protective of powers of attorney and agents, so that the agents don't take advantage of the person they have the power for. The reason this becomes so important is that the financial institutions, even more so than the healthcare providers, are very focused on whether they're going to honor a power of attorney. It's not whether it's legal or valid, it's whether they're going to honor it. Are they going to feel they have to figure out what New York law is? Or are they able to say, this looks like the power of attorney we've been trained to look for? And that way, if it's a Florida power of attorney, it looks like what they're looking for. It doesn't matter, as long as it walks like a duck and talks like a duck. If it barks, they're not going to be worried. And so what we're looking to do is please the people that you're going to present the document to. That's the whole point. That way, if it's current, they don't say, then they have what we call voodoo. Voodoo is the things they've been told that aren't necessarily true. For example, a power of attorney can only be good for 5 years. And if it's 6 years old, it's invalid. Well, that's not true. But what we want our clients to do is just come in and update their documents so they don't run into that problem. We can't control the misinformation that's out there in the world. We can actually draft to make sure that that information doesn't hurt the client. So and having these in place, particularly with a dementia situation, you don't have to rely on bringing in the care recipient to intercede in all of this. You can function, you can do what you need to do efficiently, operationally, and with guidance as to how to protect yourself with those documents.
Thank you, Ira. That was great explanation. What I think is key here, the one word you said, the word current, and I think maybe sometimes that's where people get a little bit mixed up, because they might have the myth that it's only good for 5 years, but they need to maybe update it maybe every 5 years to be current, and maybe that's where they're getting that from, because I certainly work with a lot of caregivers who have come to me with very outdated documents, and things have changed in the situation. Like you said, maybe a dementia diagnosis, or maybe the agent is no longer there to be the power of attorney for the person that now has dementia. So there needs to be a current, and that was great advice, because, keep it current, get ahead of the situation, because really in a crisis, you might not have any options, and you're going to find yourself in a heap of trouble if you don't keep those documents current and you come across a situation that your hands are tied. So I like that explanation. It was perfect to this situation with Wendy and Harold. And on that note, we're going to take a break. When we come back, we're going to have more, and we're going to let Daniel talk about some of the things that he likes to talk about in his field of expertise also. So we'll be right back.
Arden Courts is not just a place to live, it's a place to call home. Residential living combined with quality caregiving. This is the philosophy behind Arden Courts. Communities created exclusively for individuals with Alzheimer's disease and related dementia who would benefit from a safe and structured environment. For additional information about any of the unique services Arden Courts provides, call 888-478-2410 to locate a community nearest you. Inquire about our educational seminars, resource library, or support groups, or simply feel free to ask questions you may have about Alzheimer's and related dementias. At Arden Courts, we know, we understand, and we can help, because memory care is all we do. Remember, call 888-478-2410 for additional information about any of the unique services Arden Courts provides. You are listening to your host, Marcia Teele, an Alzheimer's disease and dementia care expert on caregiversolutions.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
At this time, I'd like to thank our national sponsor, Arden Courts Memory Care, for sponsoring this program of Caregiver Solutions Info Show. Arden Courts is a leader when it comes to memory care. They have about 50 memory care communities all across the United States, and 10 of them here in Florida, where we are from, doing this show. So they are a great resource. They help not only the person that has the memory loss, but they help the caregiver too in many ways through support groups and educational seminars. And today, because you're watching this program, Arden Courts would like to give you this free book. It's called The 36-Hour Day. It's a wonderful resource for caregivers written by Dr. Peter Rabins and Nancy Mace. It's absolutely free to you just for the asking. I would highly recommend this book if you don't have it, especially if you're a new caregiver. It's going to explain a lot of differences between the different types of dementia. It's going to give you helpful tips and advice, and you can read it from cover to cover or pick and choose the topics that are happening in your life at the moment. So this book, like I said, is absolutely free. all you have to do is send an email to delray@arden-courts.com. That's DELRAY at arden-courts.com. Tell them that you heard about this free offer for the 36-hour day book of the Caregiver Solution Info Show. Give them your name, your address, and your telephone number, and they'll be happy to give you a call or to let you know your book is on the way. If you'd rather call, you can actually call our Delray Beach location and ask for the memory care advisor. And the phone number for the Delray location is 561-498-5552. That's 561-498-5552. They'll be happy to, again, mail this book to you wherever you are in the country or out of the area. We have a lady that lived in Hawaii and heard our program, and she was just so thrilled to get the book. So give us a call or send an email to get your free copy of the 36-hour day. So we're back with the show, and my special guests are Daniel Smith and Ira Wiesner, and they are from the law offices of Wiesner and Smith called Advocates in Aging. And we're talking about things that caregivers need to know and do and have in their life to help them along their caregiving path and to avoid situations that could be in a crisis and then their hands are tied. So I want to let Daniel jump in here for a minute and talk about something that he really enjoys doing and helping with, and that is with the veterans information that you help caregivers sort of figure things out when maybe the patient or the person that needs care is a veteran. And Daniel, you have some expertise in this because you've been doing it a long time. And how important is it for people to try to coordinate benefits between maybe VA benefits, between benefits that they might get through other government services, or is there a need to coordinate that? What's your take on that, Daniel?
Yeah, a very great question, Marcia. I think it's very important. A lot of my clients, too, I have veterans and their family members and caregivers. Really, they're not really even sure what benefits mom or dad may have, or the veteran or their surviving spouse may have, and what's available to them. That's probably the number one thing. There are so many benefits available for veterans out there. But after the veteran finishes their service, there's not a course or a class to give them. They're kind of on their own to help figure things out. Now, we do have local veteran services organizations that are actually affiliated with the county. We have one in here in Sarasota County that will assist veterans and their families with applying for these benefits on their behalf, the veterans or their families, free of charge, which is very nice. But it's very important to understand the types of veteran benefits and what those provide. So one of the main programs is the Veteran Pension Program. Now, this was designed for low-income veterans to assist with not only home care, but aid and attendance as well. So oftentimes you'll hear it called VA aid and attendance. But it's part of the pension program, and there is an asset and income test on there. And a lot of times, veterans may try to apply for that on their own, and they may just get flat out denied because they're going to review financial statements and see they're above the income or asset cap. So it's important to know the type of program and which ones you have to financially qualify for. And it may serve the clients and the caregivers good to have an attorney look at that before filing the application. Otherwise, they may get denied and prevent getting benefits for several months before they can fix everything. The other type is the VA compensation program. That's disability compensation. So if the veteran was combat wounded or has a service-connected disability, that's a separate program, and there's actually a higher pay allotment for those service-connected disabled veterans and their surviving spouses as well. So it's important to a lot of times the veterans aren't sure what documents they need, but the VA will assist the veterans and their families in getting those. They actually have a duty to assist in applying for those. So a third important thing to remember is if the veteran or the surviving spouse is going to need long-term care in a skilled nursing facility, always remember Medicaid down the road too, because you don't want to do planning and then forget about the big pot of Medicaid money for skilled nursing that the veteran might need and you don't want to do transfers or something that may jeopardize eligibility for Medicaid down the road, which is also available to the veteran and other seniors. So that's a great question, Marcia. Thank you.
So Daniel, have you had situations where maybe a family has tried to fill out some of these forms on their own and maybe didn't complete a box or checked the wrong box or left something blank? It gets denied, and then they keep doing it with other applications for other types of benefits, and they got themselves in a hole that kind of maybe they couldn't get out of. And if they do that, is there hope for them by coming to someone like you as in elder law and dealing with VA benefits, or are they just lost forever?
No, absolutely. No, that's a very great question. That if they are denied, it's important to note that there's going to be a letter with a deadline to appeal on that letter. So it's important that if the veteran gets denied, don't panic. It's fine. You can always appeal that. But I would recommend taking that to a VA accredited attorney, which I am one, to have them look at the denial and possibly prepare an appeal on their behalf if there's a good reason to appeal it. And usually there is. Usually what I've seen in my practice is you didn't, you filled out, you missed one section of a form and got denied, or didn't provide one financial statement, but everything else checked out. Or maybe the VA misinterpreted the level of care or denied a service-connected disability without adequately reviewing the veteran's record. So there are many reasons why the benefits are denied, but always consult with a VA accredited attorney if you can. Obviously before the appeal deadline runs out, because then the veteran can't get back pay for the date they initially filed the claim. If you wait till after the 1 year appeal deadline in the case of the initial denial, after that you have to refile the claim, and then you can only get benefits as of the new claim date. So that's why I say always make sure you talk to a veteran. And Marcia, I see you shaking your head. I know it doesn't make sense. They fought for our country, right? And this is what we're doing, and then our own federal government is denying them benefits. It's a head scratcher, but yeah.
It sounds complicated, and so I'm so glad that you know the ins and outs, because you're talking about all of these different things you have to do and the deadlines, and if you don't do this, you do that, and caregivers are already so overwhelmed that this boggles some people's minds because they don't know where to start. So I'm so glad that you're there to help people through this and give that information and let people know that there's help and there's hope for everything that they need regarding all this elder care. I mean, it is so important. So I want to toss back to Ira now and go back to something regarding our hypothetical couple, Wendy and Harold, that we've been talking about, and they have all their documents. And I want to talk about their do not resuscitate order and within their advance directives, and because we didn't talk about a DNR. So Ira, can you explain the difference with the terminology between a DNR and a healthcare surrogate and a healthcare directive, and how all of that plays in together?
Absolutely, Marcia. So this is the picture you have to have in your mind. Where are you getting service? Where are the healthcare professionals dealing with you? If they're in a hospital setting, your advanced healthcare directive, living will, does everything you need it to do in that kind of a setting. And the reason for that is there's medical supervision over what's transpiring, and that there's an opportunity to verify your wishes in your document. Take a different scenario. You're walking through the mall and you collapse. There's no doctors. You could have your living will literally in your back pocket. Someone calls 911. When they come there, they could hit you over the head with the advance directive. They are not allowed to honor it because there's no medical supervision. That's where you need the DNR, and the DNR means do not resuscitate. It's a separate document from your living will or your advanced healthcare directive. It must be on yellow canary colored paper. It cannot be phosphorescent orange. It can't be brilliant green. We had a group of physicians in town that thought they would help their patients by doing all the DNRs in this incredible fluorescent orange. And I had to call them up and say, you got to get them all back. They are invalid. They must be on canary paper, number one. Number two, they must be signed by your doctor. And what the government wants is they want you to go talk to a doctor, talk to your physician, and get some guidance. Why do you not want to be resuscitated? Are you depressed? Do you have some issues? Do you have a terminal illness that you're terrified of? Why do you want to have this document? Because once the doctor signs it and you've got it with you, if someone calls the EMTs, they're not going to resuscitate you. So what the legislature wants is that there's been a doctor there to say, what's going on here? Is it legitimate? Is it in your best interest? And you know what you're signing. I can't begin to tell you, Marcia, how many times I've looked at clients bring in their paperwork and they've got DNRs in there. And my first question to them is, what medical condition do you have that warranted you having a DNR? And they look at me like deer in the headlights and they go, well, what do you mean? I'm fine. I don't want to be killed and I don't want to die. And I said, then let's take this paper and rip it up because you shouldn't have signed this. So the DNR is a very powerful document. You should go ahead, Marcia.
I know. I just, what you just said, because it's people don't understand what it means, and sometimes it's a double negative. I don't want to do not resuscitate because it's like a double negative. And I think sometimes they don't understand all that means and they could be picking the wrong thing, like you mentioned.
Absolutely. They just think that that's part of the natural package that they need, and it really, really isn't. And so you just have to have the right guidance. And if we can have the conversation, and then we'll send the client with the form to their physician to have that conversation. Having the conversation is so important, even in what we were talking about before, the advanced healthcare directives. Don't appoint somebody to be your advanced healthcare surrogate and not have a conversation with them about it. Let them know what your feelings are, what your wishes are. Let them know they've been appointed. One of the saddest situations is to get a call from somebody, oh, your uncle is in the hospital and he appointed you as his healthcare agent. And you're in another city and you haven't talked to this uncle and you have no idea what his real values are and what he would want under the circumstance. Communication is the most important here. And that communication should be done with your memory support people, the caregivers you're working with, so that everybody is on board as to what the game plan is. And that way people don't question because they already know. And it's efficient and it's also far less disturbing when you have to implement them. If I could, Marcia, on that point, if I could just add one special thing that I wanted to touch, and this is for the caregivers. And this is going to sound harsh for the caregivers. But as an elder law attorney, there's not a lot that I can do for the person who has the dementia, other than to assure that their wishes will be carried out and the people they want protected will be protected. My big concern is the caregiver and the stress the caregiver goes through. And they put off placement based on a line in the sand. could be he doesn't recognize me anymore, she's become incontinent, whatever that line in the sand is, and they push it. They want to stay with the caregiving as long as possible because they feel that's their role. And caregiving can be very detrimental to your health. It is a stressor that can lead to death. And so a caregiver has to make a decision. Are they the caregiver only, or are they the spouse or the parent or the child? Because they didn't get married to become a nurse. And so when that role falls on them and they accept that role, which is what we expect, they have to understand that it can be very difficult for them, not just in taking care of the person, but in their own mental and physical well-being. And so for all the caregivers, don't put off your own health care, because at some point in time, you won't be a caregiver and you won't be there if you don't take care of yourself. And so I think for a caregiver, as hard as it is, and the book that you are giving to caregivers, the 36 hours, explains so much of this, but it's different when you live it. And it's important that you talk to your family and say, you know, this is really hard on me. I'll do it. And I'll do it with a smile on my face and love in my heart. But watch out for me, because I'm not going to recognize if I'm not well enough. And so I think caregiver health for themselves, getting respite, the ability to utilize services at a facility like an Arden Court, just to get time to regenerate your engines, replenish your batteries, and put a happy face back on your life. And that just empowers you to do what you do. It's a very difficult job. So I wanted to make sure I added that, because care is the one person in the group that seems to be ignored. You hear dementia, you hear finance, you hear all this stuff. You're very operational, but that's the person you really need to give the attention to.
Well, that is so true, because we've all seen caregivers that have been stressed out, burned out, even going to the hospital and being in the hospital instead of the person they're caring for, because they landed there because of the stress of caregiving. And so, but that brings me to sum up what you just said about taking care of themselves and knowing where they can get help. So although you and Daniel are, elder law, and you can help with all the legal and all the documents and the VA and the Medicaid and all of that, I think what it's important for everybody to see here is that you all are also excellent resources to caregivers for everything else they might need. You mentioned respite, you mentioned memory care, you mentioned nursing home. You know the community, you know your people, you know those caregivers, and you're able to refer them, recommend to them places where they can go additional help once they leave the law office, because the law office takes care of the legal part, but that's not where it all ends, right? So what's the next step? And I want people to know that if they have an elder law attorney, it's sort of your mission to know how to help everyone in the big picture, to not just stop right there, right? They need more, and you obviously know about this book, which is awesome. And so I applaud you both for that. Daniel, if people are listening to this program today and they have questions, or they heard something they weren't quite sure about, is there a way that they can contact your firm and talk to somebody about that?
Absolutely, Marcia. The best way is to call our main office number. It's area code 941-365-9900. We do free 30-minute consultations on your legal needs, anything affecting seniors. You can also, to learn more about us, visit our website at www.wiesnerlaw.com, and that's WIESNERLAW.com. And you can review our bios, and we have blog posts on there about various issues, and a contact form if you prefer to not talk to somebody. I know a lot of the younger millennials who may have issues with their parents or grandparents don't like using the phone. They prefer to text, or we have a contact form. They can submit the legal issue and a way to contact them to set up a consultation that way as well. And we've had a lot more client contact submissions on the website as well. So yeah, and we're located in Sarasota, Florida. We're at 328 North Rhodes Avenue, right off Fruitville Road in Sarasota. So thank you, Marcia.
Oh, you're welcome. Yes, Ira.
And I just wanted to add that on our webpage we have instruction videos where Daniel and I will take a specific area of the law and pretty much give all the basics that one would need so that they can clear their minds, understand what the territory is, understand what questions to ask, whether they come to us or not. And we've got them on guardianship, on Medicaid qualification, on estate planning, and we just keep rebooting them and putting new ones up. And our goal is education for self-help.
Well, that's great, because people need this. They really need it. Now, you mentioned guardianship. Can you give just a little explanation about when guardianship would be necessary?
Daniel?
Yes, I can, Mark. Sure. Actually, and it's June 15th, which means today is World Elder Abuse Awareness Day. If you didn't know that, it's a day dedicated to recognition of the abuse, especially financial abuse that elders face. And so with that, when I talk about guardianship, it's really a system set up to protect those with diminished capacity, and which most often affects seniors. So it's important to understand that guardianship is it's a court process, right? That's begun with the filing of a petition to determine incapacity, right? So we do all this planning, right? Advanced directives, a durable power of attorney, because we want to avoid guardianship. That's the goal. But actually, guardianship can be helpful in certain cases, such as, like I talked about, if the bank suspects that there is some type of fraud going on, if they're getting competing powers of attorney, right? Son went to one attorney and daughter went to the other for dad, and so they're just going to put a freeze on the account and let the guardianship court take care of it. Maybe the co-agents disagree. I know if you put me and my brother Thomas and have to make decisions about mom or dad, we're not always going to agree at the same time. And if we can't come to an agreement, the physician's going to say, hey guys, I'm sorry, you need to get a court order from the guardianship court. Same thing with the financial institutions too. They may just put their hands up and say, you need to sort it out with the judge and get an order about this. So yes, all the estate planning can be very beneficial, but there are times when we may need the guardianship court to step in, and maybe the seniors don't have anybody local that can assist them and didn't do any planning, in which case, the caregiver should consult a guardianship attorney, and we can determine if a guardianship may be necessary.
Wonderful. Well, I wanted to get that in because we're about out of time, and I thought that was a real important topic to bring up. I want to thank you both for being here with us today on the Caregiver Solution Info Show. Thank you so much, Ira. Thank you so much, Daniel. Attorneys, elder law attorneys from the law firm in Sarasota. You've been listening to them today. They are awesome. They are experts in their field, advocates in aging, law offices of Wiesner and Smith. You can give them a call at area code 941-365-9900. Thank you, gentlemen, for all your help. I appreciate you very much.
Thank you.
And thank you.
Thanks for joining us for this week's Caregiver Solutions with Marcia Teele. Join us next week as Marcia, who has 15 years of Alzheimer's disease and dementia care experience, brings you more needed information to help with the care of your loved one. This show can be seen again on caregiversolutions.info, and questions can be left on the site, which may be used on the program to help others. See you next week for more Caregiver Solutions.
The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station.